last but not least, proportionality of impact. All of those are in Gatirao Pitaminia, and they are well known to the courts. My lords, let me focus on the last one. The first two have been extensively canvassed by my learned senior colleague. But in so doing, let me state that I have the benefit of a perspective of the fiscal impact of conservatory orders, given where I sit at the central bank. My lord, let me put stark numbers on the table for the court to understand. My lord, a transaction of 244 billion shillings is on the table. And my colleagues may sit and argue, as they have done, that there is a danger of dissipation of the subject matter. And in the same breath, they argue that there is no loss from conservatory orders being issued. The following is the loss. My lords, put 244 billion shillings conservatively in a money market investment at 10%. Every year, those funds would yield 24.4 billion.
So you saying the treasury is going to invest?
No, but the point I'm making is the following. Let me complete my point, my lord.
It is very, I would really hate to interact with my learned senior counsel. But is that information in an affidavit? And secondly, he admits that he is part and parcel of this particular transaction, and therefore he should be an expert witness, and not representing the regulator.
If I may finish. Yes. Yes. My lord, the point I was trying to make, as my learned friend pointed out to you. Yes. Correct. Correct. Now, absolutely. And my lord, what I want to bring to the fore for the court to keep in mind is the National Infrastructure Fund will be implemented progressively, naturally. So the funds will not be kept in a current account. That impact translates to 72 million shillings every day. And what is the converse? The converse is,
again, I'm very sorry for this. Is that in an affidavit so that we can advert our minds on it?
The matters the court can take judicial notice of.
Those are very technical matters as for counsels and the court to take judicial notice. Mr. Musangi, the chairperson of Central Bank, has information which the court does not have. And he should put that in an affidavit so that we can cross-examine him.
Yes,
we do not have...
Take your seat.
Yes, thank you.
So do not... What we say is...
My lord, yes.
So do not use it.
I'm not using personal information. I'm not using central bank information.
Yes.
I'm only...
And I'm questioning you again.
Yes.
Tell us facts or arguments in the context.
Absolutely. My lord,
nothing outside.
Nothing outside.
Yes.
And my lord,
yes. And your honor, we cannot allow false analogy in court. That's a false analogy.
No,
it's
sit down. I'm to the issue. Sit down. I'm told him I was talking. Yes.
My lord. Yes. May I just be clear that I'm not talking about central bank. Anybody with money in Kenya knows what a fixed deposit is. Anybody with money. It's not central bank. Let me move on, my lord, since they fear the impact from the side of the treasury. Let me talk about...
Through an affidavit, you will have no problem.
Absolutely. And my lord... Yes. Correct.
Yes.
My lord, let's look at it the other way. As long as there is a status quo in order, the shares cannot be paid for. That is a fact. And if you extend a conservatory an order today, or create one because it has expired, if you issue one, those shares cannot be paid for. My Lord, if we hypothetically finish this case in July, and you issue a ruling telling the petitioners your case had no merit, the people of Kenya will receive the same 244 billion shillings, not a penny more. In which case, what would have happened is you would have granted a conservatory order to a party that has not proven its case. And the impact of that order will not be remediable by any person sitting in this courtroom. Not one. And at the same time, my Lord, and this is in the affidavit, the impact on our capital markets in terms of confidence will have been absolutely destructive. What's the remedy for that? My learned friends were at pains to tell you about 40 million subscribers in Safari. My Lord, government, the National Treasury, and Parliament represent all of us. Not just 40 million, all of us. And the people of Kenya have had their say through the parliamentary process, through the public participation underpinned in that process, in compliance with the law. And ultimately, on 12th March, the sessional paper from the Parliamentary Select Committee was placed before the House with a motion for its approval after all these processes have been complied with. So we have constitutional compliance, statutory compliance, and procedural compliance. You have not been told one single breach of any of those processes to encourage you or convince you to issue a conservatory order. In fact, in the main petition, the only pleading of a breach was that Parliament is not being involved in this process. And the facts belie that assertion, including the application by the petitioners for recertification, which then attached the motion under sessional paper number 3. So, my lords, if you consider the fact that the doctrine of separation of powers, the principles of public participation have brought in 60 million Kenyans into this process by their representatives or by the people who made direct submissions, what then are we stopping? And my lord, when you consider this court's broad